Thanks, John. So, we've spent a lot of time getting this technology. It's not going to be as high-flying and pyrotechnic as I would like. About this, the ink blot is basically this is the peak right here. It goes downhill from here. But, okay, so we were talking in the beginning of the panel, the first panel, about how should we interpret the Constitution? I mean, that was really one of the main themes. And by the way, I want to thank Patrick for stepping in and giving a wonderful talk. And one of the things that Patrick talked about is, do affirmative action policies violate equal protection, right? And he was sort of suggesting ways to understand equal protection. Also questions, for example, is there a right to privacy that protects a woman's right to choose? Is mandating health care part of commerce among the states? Also, does the Equal Protection Clause invalidate prohibitions on same-sex marriage? Those are questions about how should we interpret the Constitution. For instance, right, should we look to original meaning or should we treat the document as a living one, right? It makes a difference, right, how we interpret these vague phrases. This is the nature of most debates over the Constitution, and debates we ought to have, don't get me wrong. But I will not be answering this question, thankfully. So it won't be, won't be answering that question. I'll be answering a conceptually prior question, and it's this: why is the Constitution superior to laws and policies passed by either Congress or the state? Right? So let's think of it. When you think of a prohibition on same-sex marriage, Adam had talked about the Defense of Marriage Act. That was a federal law. You also have states that limit marriage just to opposite-sex couples. That's a state law, right? So whether you want to think equal protection, whatever it means, leave that to one side. If it turns out it means that those laws are in violation of it, are inconsistent with it, right, that means that the court should strike them down. But why, right? So I want to leave the interpretive side question to one side. Why should they why should they be struck down? The idea is that the Constitution is the highest law of the land, right? It's the highest law of the land. It's the final authority on whether governmental action is constitutional or not. So for instance, I'm going to give you an uncontroversial example. A law that denied women the ability to vote, right, would be unconstitutional because it violates does anyone know? It could, but what even clearer, 19th Amendment, right? Because the 19th Amendment says you may not limit the franchise on the basis of sex. So it should be struck down. It's unconstitutional. And the question is why? So what? Why does the Constitution trump, right? I mean, simple question, right? That's one of the reasons why, it's good actually that maybe I didn't go first, right? Because you all had very spirited debates. And now you can sort of step back and think, well, why are the debates so spirited, right? Why does it matter? Why do we care? Okay, I'll answer this conceptually prior question. So my talk today will be in three parts. First, I'm going to look to the text of the Constitution. This is why I wanted these slides, right? You really didn't want me to write on the board. The text of the Constitution deems the document itself superior to laws and policies passed by Congress or the states. Constitutional amendments require more democratic input than laws and policies. And then finally, the court ought to strike down those laws and policies that are inconsistent with the Constitution. So one thing to look at, and I encourage all of you to do it, is to read the Constitution. To read the Constitution. It's not that long. It was meant to be read by everyday folks that ended up ratifying it in 1789. It has 7 portions to it, or articles, and then various amendments, 27 amendments, the first 10 amendments being the Bill of Rights. And so I'm going to focus on Article 1, Article 5, and Article 6. See, you couldn't really do that without the technology. And so I want to suggest to you those are key sort of articles in thinking about why the Constitution is the highest law of the land. Okay, so text. First, Article 1 is how a bill becomes a law, right? Sort of very simple, as you all know. It starts off as a bill, goes to the various houses. It has to be approved by both of them. If it's vetoed by the president, it requires a 2/3 vote to override the veto. I've underlined, the underlines are not in the Constitution, by the way, so. One time I gave this talk and students said, oh, wow, they actually bolded it. I'm like, no, they didn't. They didn't. That's so these are my highlights. Article 1 is talking about a law, right? It's talking about a law, right? This is how a bill becomes a law. So that's Article 1. Article 5 is how you amend the Constitution. Okay, and so what does it take to amend the Constitution? Well, generally it takes 2/3 of both houses to propose an amendment, and then it takes 3/4 of states to ratify it. It takes 3/4 of states to ratify it. What's interesting to note is once it's ratified by the 3/4 of states, it is for all intents and purposes part of this Constitution, right? So amendments, although they are listed separately, are part of the Constitution once they've actually been ratified, right? They are now the Constitution, right? So when you say the Constitution, you mean we just mean not just the Articles 1 through 6, we also mean the 27 amendments. Okay, so remember, this was about, these were laws, right? A bill becomes a law, and this is when amendment is passed, it's part of the Constitution. It's part of the Constitution. Okay, now Article 6, right? This is the crucial sort of statement here. It says the Constitution, right, which I just told you includes not only Articles 1 through 6, but also any amendments that have been so ratified, and the laws of the United States. So when it means laws here, it go back to Article 1. Those are the laws that are passed by Congress, laws of the United States, which shall be made in pursuance thereof. When it's saying pursuance thereof, what? The Constitution, right? So that Article 6 makes clear that laws, Article 1, have to be consistent with the Constitution and the amendments which so become part of the Constitution. Then it goes on to say, shall be the supreme law of the land, right? So the Constitution shall be the supreme law of the land, and judges in every state shall be bound thereby, and anything in the Constitution or laws of any state to the contrary notwithstanding. That means that anything in a state constitution, for example, Proposition 8, right, which amended the California Constitution to say marriage is only between a man and a woman, or laws of any state, to the contrary. Contrary of what? The Constitution notwithstanding. So anything that's contrary is also invalid, right? So it's not only federal laws, but also state constitution or state laws that are inconsistent with the Constitution are invalid. So that one, congressional laws must be consistent with the Constitution, and state laws must be consistent with the Constitution. So that's the text of the document. The text of the document actually makes clear why the Constitution is the superior document. Okay, so if you take Article 1 plus Article 2, you get Bruce Ackerman at Yale Law School has made this distinction and talks about it and takes it even farther and suggests other ways that we can engage in higher lawmaking, but leave that to aside for now. Higher lawmaking is the Constitution and amendments. Lower lawmaking are laws passed by Congress or the states. So that's the textual argument. The second argument is that the Constitution and amendments are more democratic than state laws and policy. So what do I mean by that? So higher lawmaking, right, and this is Article 5. Articles 1 through 7, right, how were they ratified? Well, they were actually ratified in convention in states, right, ultimately 1789. They were actually only binding on the consenting states. In fact, it took 9 to do it. For example, Rhode Island, right, was one of the last to ratify it. So actually, George Washington was being sworn in. Rhode Island wasn't actually part of the Union, right? They hadn't yet ratified it. I thought, well, I best we should, and they did. And so it actually required 9 states, and it was actually conventions in each state. The 27 amendments have required 2/3 of Congress, right? Go back to Article 5, and 3/4 of the states. Now, compare this with lower lawmaking. Congressional laws only require a majority of Congress, right? If there's a presidential veto, it requires 2/3. And state laws require a majority of state legislation. Often they have the same principle. If the governor vetoes, 2/3 of the legislature trumps. But what's interesting is congressional laws, who is not involved in making a congressional law? What body is not involved? That's true, but the Supreme Court isn't involved here too. What body isn't involved here? The president's also not involved here, right? What's crucial? What's not involved? The states, right? I mean, after all, we have this notion of dual and overlapping sovereignty that includes both the federal government and states. The amendment process requires involvement in a way from both federal and state governments, whereas congressional laws you don't need a state, and state laws don't require anything to do with Congress, right? So there is something that's not only more democratic from a quantitative perspective, the numbers are higher, right? You need more Americans to amend the Constitution, but also from a qualitative perspective. The idea is that both sovereignties, and of course this is a way in which, if you think of the history of the Constitution before the Constitution, there was another document, Articles of Confederation, where, in fact, the states were sovereign. And so when the Constitution came in, it created a new sovereignty while recognizing the old one, right? And so this is the tension in federalism, and both are required to amend the Constitution. So that's also why the Constitution, I want to suggest, is superior to laws and policy, because it requires both Congress and the states. Okay, so it's harder to amend the Constitution then than to pass laws. It requires more democratic input, and there are thousands of federal laws, state laws, and only 27 amendments. Surprise, surprise, right? So the third then part, okay, so that was the text, that was a notion of sort of democratic theory. The final, I want to conclude by suggesting the court ought to strike down laws that are inconsistent with the Constitution, strike down inconsistent laws and policies. Okay, so where do we get that from? So Article 3, Section 2, says the judicial power shall extend to all cases arising under this Constitution. And Article 6 says this Constitution shall be the supreme law of the land. So thus the judicial power shall extend to all cases arising under the supreme law of the land. So in a way, the judiciary has been endowed with the power, right, to decide cases arising under the supreme law of the land, which is the Constitution. That's why this court ends up deciding whether laws and policies are inconsistent with it. Now again, that puts a lot of power in the Supreme Court. How do we go about interpreting those clauses? Again, that's, I think, legitimate debates, but that is a conceptually prior one to think, well, why is it that they have the power to do so? So that means that when there's higher lawmaking, it trumps lower lawmaking. You don't know how long it took me to do this, and I know it doesn't seem that great or awesome, but it took me a while. Okay, so just want to flag that. So laws that violate the Constitution then must be declared unconstitutional, and so a law that denied women the ability to vote would be unconstitutional. Because of the 19th Amendment, right, the Constitution says the franchise may not be restricted on the basis of sex. The court's role is to enforce the Constitution to ensure that lower law is consistent with higher law. So if there's a law passed by the state saying women may not vote, that's going to be inconsistent with the Constitution. The law is unconstitutional. The court must strike it down. And why, again, go back to the textual argument and the democratic theory argument. So to conclude then why the Constitution is the highest law of the land, the text places the Constitution above laws and policies passed by Congress and the states. Amendments require more input from Americans from both states and Congress, and laws and policies that are inconsistent with the Constitution are therefore invalid. Court ought to strike down such laws and policies as unconstitutional. Okay, I will end it there. That's 15 minutes, and thank you.